Friends, session number 34 of the series on military law would explain what is Armed Forces Special Powers Act, where does it derive its authority from, what does it actually say and what is its text, also what criticism has it generally attracted, whether the act has been subjected to judicial scrutiny and if so what, and also what is the way out. Now, proceeding further in this session, you would appreciate that the framers of our constitution could not have at that stage estimated the unrest that was to follow and came to be seen in decades ahead, the extent of hatred, violence, and threat to the sovereignty of the country. They had the wisdom to enshrine and incorporate in the Constitution the emergency provisions that deal with such situations and threats to the security of the country. In this regard, first, one can see Article 352 that deals with proclamation of emergency, and it relates to the power of the President of the Republic to make a proclamation of emergency where he is satisfied that security of India is threatened by war, external aggression, or armed rebellion. So the threat has to emanate either from war or external aggression or armed rebellion, the three contingencies indicated in the article. Next is Article 355, which lays bare the duty of the Union, and it states that it is the duty of the Union to protect every state against external aggression and internal disturbance, and to ensure that the government of every state is carried out in accordance with the provisions of this Constitution, and therefore the governance has to take place in the spirit of the Constitution. The next Article 356 deals with failure of constitutional machinery in the states, and it relates to provisions where the President may, by issue of proclamation, set in motion emergency provisions that have been elaborately indicated and inserted in this article. Now, with this background, we move to 7th schedule that relates to division of responsibility between the state, the union, and what is known as concurrent list. List 1 is your union list, and I will take you to the first three entries. The first relates to defense of India. Now, defense of India and in war contingencies for the prosecution of the defense, and once the hostilities have ended, for collective and effective demobilization, well, that is within the domain of the Union. Also, the next entry relating to naval, military, and air forces or any other armed forces, and entry 2A, which pertains to deployment of the armed forces of the Union subject to the control of the Union or any contingent or unit thereof in state in the aid of civil power. So one has to bear in mind and appreciate that these three entries have been given to and have been included in the Union list, which have a bearing on the discussion today. Insofar as list 2, the state list, is concerned, the state is responsible for framing of laws, legislation, firstly with regard to public order, but excluding the use of any naval, military, or air force, and then police. Very short point, it makes it clear that naval, military, or air forces cannot be used by the state for maintenance of public order, and whereas police, including the railway police and village police, is within the domain of the state concerned. Now, With regard to the emergency provisions and the division of responsibility by the union list and state list, firstly, it is to be appreciated that the duty of the union in the matters of national security is behind the clear-cut demarcation in the powers of the parliament and the state legislature in this regard. Point being made is that the aspect of national security, the subject of national security has been given to the parliament and it is not with the state legislature. And the second point is that where the Indian polity is of a pluralistic nature, and regard being had to the fact that there are multiplicity of religions and languages in India, there are ethnic divisions, at times there may be apparent lack of accommodation in political thoughts, uh, regard being due head to the economic disparities, geographical imbalances, and all these put together may give rise to unresolved aspirations. And the group of people may at times become impatient and they may discard the democratic functioning and ethos and they may resort to violent means. And what happens then? Is our constitution, are our laws robust to deal with such a situation? And in these contingencies, it needs no reiteration that military is the final option. A failure of the state administration to maintain law and order may develop in situations which are disturbed and dangerous. Now, these are the legal words, legal terms, disturbed and dangerous, and to a situation where the police and other armed agencies available to a state appear incapable to control such extraordinary situation. And in all these events, it is the armed forces which are the ultimate weapon available with the union to deal with such violence or disturbed, dangerous situations. There is nothing beyond the military which is available to a sovereign state. It is for these situations that Armed Forces Special Powers Act of 1958 has been crafted. The arms regard being had to three main difficulties which appear when the armed forces have to be deployed, have to be provided to a state. Firstly, armed forces personnel have no statutory authority to be deployed or act within the country against their own citizens. Military has no, under law, has no authority to for deployment within the state where it has to act with its own citizens. Number two, the state government cannot directly call for military. Military is an agency, instrumentality of the union, and therefore a state or a union territory which needs the aid of military to assist its forces has to make a requisition to the union, to the Ministry of Home Affairs, and which would move to the Ministry of Defense, and who has the authority functional over the military. And in such a situation where the military has to be provided, then military personnel, they need to be suitably protected for actions which they have taken in discharge of official duties. And it may also be borne in mind that after normalcy of power, where different political parties may assume power, there may be a situation where for public convenience, it may become necessary, it may become expedient for those political parties to proceed with the prosecution of the armed forces with a political objective in mind. And this, in nutshell, is the need and purpose of the Armed Forces Special Powers. Firstly, it talks about what is a disturbed area and dangerous situation, when these two become relevant, who would make a decision that an area is disturbed or dangerous, and how would this be made. It also talks about the powers to be wielded in operations in military missions by non-commissioned officers and above. Thirdly, it lays down what is the duty of the armed forces in such situation and how suitable legal protection can be given to them with regard to actions that they have taken while discharging their functions. Now, for that we move to section 3. It says that where the governor of a state or administrator of a union territory or the central government is of the opinion that whole or any part of such state or union territory is in such a disturbed or dangerous condition that the use of armed forces in aid of civil power is necessary, the governor or the chief administrator or the central government would issue a notification in the official gazette which would declare that whole or such part of that state or union territory is become disturbed or dangerous and use of armed forces has become necessary. Section 4 of Armed Forces Special Power Act enumerates the special powers that come to be vested in any commission officer, warrant officer, NCO or equivalent. Number 1 is regarding use of force. Clause A says if he is of the opinion that it is necessary to do for the maintenance of public order, then he is required to give such due warning as is considered necessary and thereafter fire upon or otherwise use force even to the extent of causing death. Against whom? Any person who is acting in contravention of any law or order for the time being in force in the disturbed area, prohibiting the assembly of 5 or more persons, or they are carrying weapons which are capable of being used, things which are capable of being used as weapons, firearms, etc. So this is the first authority with regard to use of force. The second is to destroy any arms dump, prepared or fortified position. If anti-national elements or insurgents, militants, terrorists, whosoever are there in that disturbed area, if they have set up any arms dump, prepared or fortified position or a place from where they can launch attacks, then they can be destroyed, and this also includes any hideouts. Thirdly, they have the authority to arrest without warrant any person who has committed such an offense or is likely to commit such an act. And lastly, they can enter into any premises and search without a warrant or they can arrest where such arms, ammunition, explosives, substances, etc. are believed to be unlawfully kept. Now, these are the 4 specific powers which have been given to the persons of the rank of non-commissioned officers or above the armed forces. And next is section 5, which says that if they arrest such any person in a disturbed or dangerous area, then he is to be handed over to the police with the least possible delay, and together with a report about the circumstances under which such a person was apprehended. And lastly, section 6 talks about protection to persons acting under this act. No prosecution, suit or other legal proceedings shall be instituted except with the previous sanction of the central government against any person who has acted in furtherance of the Armed Forces Special Powers Act, the powers that it provides to him. Now, the provisions of this AFSPA have been at times criticized, and the criticism is mainly on 4 counts. Firstly, it is said that some states or part of the states have been under AFSPA for decades. Secondly, it is said that this act gives draconian powers to the military, and this is because there are words that are there that even to the extent of causing death. Thirdly, that the operation of this act has resulted in violation of human rights. And lastly, that wherever there are violations of the act, and prosecution is sought of armed forces personnel, the central government sanction is not easily forthcoming. The legality of Armed Forces Special Power Act as a legislation and the operations came to be scrutinized by the Supreme Court in a famous case called Naga People's Movement of Human Rights versus Union of India. Was carried in the reports in 1998, judicial reports. It was a 5 judges bench. And finally, the court held in this case that though it was criticized as a colorable legislation or fraud on the constitution by those who were opposing the act, it is not so. Secondly, it said powers under section 4 and 5 cannot be said to be arbitrary and unreasonable. They are essential for the armed forces personnel for discharging their duties effectively. The Supreme Court, however, put in place certain restrictions, and these restrictions which appeared in its judgment were: number one, they said that having regard to the matter that for decades the Act has been in operation, periodic review of a notification is necessary, and each notification will have a shelf life of 6 months, and after 6 months a review would be necessary. Number two, with regard to prosecution of armed forces personnel, any order of the central government giving sanction or withholding sanction or declining sanction would have to be a speaking order that can be subjected to judicial review. Thirdly, the do's and don'ts that have been issued by the Chief of Army Staff for the troops, they need to be strictly followed. And lastly, the Supreme Court said that where human rights have been violated or there are victims who have suffered, they need to be provided compensation. At the same time, while putting these restrictions, Supreme Court facilitated action by the troops in two manners. Firstly, it permitted retention and weapons and explosives that were captured during an operation by the army, and of course it said that when needed by a judicial body or a court, they would need to be produced, and it also allowed the troops to carry out interrogation of those who have been captured. Now it is being felt in some quarters, and it is the suggestion that suitable steps can be taken to humanize Armed Forces Special Power Act, and one of that way is to frame suitable rules and devising other executive steps. Second decision which needs to be studied is extrajudicial execution victim families association. This decision of the Supreme Court of 2016 is also worthy of note, and it gave a ruling that power to cause death of an enemy while on active duty has to be under definite circumstances which need to be prescribed. In other words, the armed forces should have clear-cut rules of engagement. And secondly, the court clarified and highlighted that there is a difference between right of self-defense and use of excessive force or retaliation. Now, right of self-defense on one hand can be accepted, but not is the case. This is not the case where use has been made of excessive force or there is an impression that retaliation has been carried out. The other case is Lorem Deben Singh versus Union of India of 2019, where the Supreme Court issued a ruling that whether alleged killing or death of large number of persons described was justified or not is and can be a matter of investigation by a special investigation team, which in case of Manipur was constituted by the Supreme Court. And in the last case of 2019, Supreme Court further remarked that it is necessary to know the truth so that law is tempered with justice and this truth was in relation to the persons who have been allegedly killed in encounter, or their whereabouts are not known, they've been arrested, not released. Then secondly, the excuse for knowing the truth mandates the act of ascertaining whether the fake encounters or extrajudicial executions have taken place. And if so, then who were the perpetrators of human rights violations, number one, and how can the next of kin be commiserated with, and what further steps needs to be taken. Now, this was the viewpoint put forth in this decision of 2019. Finally, it is to be appreciated that armed forces are the last agency of the Union to maintain unity and sovereignty of India. And in that context, Armed Forces Special Power Act is essential to help in restoration of normalcy in any situation where there is a disturbed or dangerous area as declared by a notification, but at the same time, violation of human rights must be avoided at all costs and accountability in the troops instilled. Thank you.